She has over 5 years of experience as an immigration defense lawyer, primarily working alongside detained asylum seekers and leading collaborative immigration advocacy efforts. Laila is the 2024 recipient of the American Immigration Lawyers Association Young Lawyer Award and has presented and written for dozens of immigration, public interest, Muslim, and progressive platforms. At Project ANAR, Laila's work focuses on organization administration, external relations, technical assistance, removal defense, advocacy, and communications. Next slide, please. All right, thank you. Sara Kohgadai is an immigration attorney and co-director at Project ANAR. Sara joined the team in 2023 to expand services for Afghan parolees in the Bay Area. As co-director, she works with Afghan immigrants and refugees in both English and Dari, individually and through large-scale pro se workshops. Sara also provides training and know your rights sessions for service providers and community members, and also engages in community outreach and advocates for freedom of movement for all. And we're super grateful to have both Laila and Sara with us today to share their expertise and insight. Next slide, please. Okay, so just to go over the agenda for today's session, Laila and Sara will start with some introductions, then they'll share some context and look at recent Trump-era executive orders and immigration policies and how they impact our communities. Then they'll discuss the current status of humanitarian parole and temporary protected status. And after that, they'll go over some essential Know Your Rights resources that you can use and share in your own trainings. And finally, we'll wrap up with a Q&A where you'll have the chance to ask questions of our two speakers. You're welcome to enter your questions in the Q&A box, and I will read them out to our speakers at the end of their presentation. So thank you again for being here. I'm going to pass it over to Sara now for their presentation.
Thank you, Jasmine. Let me get our slides up, and Laila is going to start us off. So give me just a second. You guys can see that okay?
Thank you. Thank you. I think we can go ahead to slide 5. Yeah, we've already covered some of the background on who we are, and we'll just get right into it with some of the context setting here, and then I will pass it over to Sara to go over some of the information to keep in mind about the rights of non-citizens as it relates to all of these issues, and some of the questions you all might have. So we want to kind of set the understanding here of what has happened since January and the broader context of for understanding the rights of immigrants, whether that's refugees, green card holders, or anyone else that you might be working with. So one of the early decisions from the Trump administration this year included the rescission of the sensitive locations policy. So this was a decades-long policy restricting immigration enforcement from campuses, places of worship, and hospitals, and made it a lot more difficult for ICE or other agencies to conduct immigration enforcement activities in those places. But there's no longer those special protections in place, which brings us to the point of those places being treated like any other locations, which we'll talk about towards the end of the presentation, so you understand what are the rights of non-citizens in those places now. But this has been one of the factors that has allowed for potentially increased immigration enforcement for folks who are accessing community services or healthcare, attending school, etc. So the next slide. Something else that is relevant here is that state and local policies might limit or could increase also in some cases cooperation with immigration enforcement, but they cannot restrict ICE. So these locations, like any others, are subject to constitutional law and are treated as either private areas or public areas for the purposes of immigration enforcement, where private areas can generally not be immigration enforcement generally cannot enter those spaces without permission. And for public areas, they do have some access to that. And there could be some gray areas about what is considered private or public, but in general, lobbies, waiting areas, parking lots are considered public. And it's within the actual buildings that or certain spaces within the buildings that may be considered private. And that's when it becomes important to understand what are the policies of any specific institution. And there is really an opportunity there to share resources and information with community members or with business owners or whoever it may be to make sure that folks are have some protections in those spaces. Can go to the next slide. And we'll talk more about the specifics of that later on. At the same time that this ground has been set for the potential of increased places for immigration enforcement to happen, what we've seen is the expansion of the tools of immigration enforcement. So one way that this is happening that might intersect with folks who are working with who have entered the US on humanitarian parole in particular is expedited removal. And if anyone works with folks who have crossed the southern border, expedited removal is something that this administration has been increasing. So expedited removal is a type of proceeding that is essentially a fast track deportation. It does not include the right to a full hearing with an immigration judge. It is effectively a pre-screening before someone has the opportunity to present their full asylum claim, and it does not have the typical safeguards that are in the normal immigration process, which is even less than what exists in other types of legal proceedings. But it doesn't even include that bare minimum of access to legal support and due process. So this expansion of expedited removal has applied primarily to people who have been within the US for under 2 years. And it previously was generally restricted to people who are near the border, but now it has been expanded nationwide to folks who have been in the US for under 2 years without a permanent immigration status. And the administration has included in their priorities for that people who may not have filed their asylum application yet, and others. So that's where some folks may want to consider what types of documents and evidence to have of their residency in the US for longer than 2 years as applicable, which again, we'll talk about some of those ways to protect yourself later on here. But this is this enforcement of expedited removal is happening in a couple different ways, including what you may have seen with enforcement activity happening in immigration courts. If folks you work with may not have their cases in immigration court, but we have seen some instances of people being transferred to immigration court. So this could happen. And the tactics that the government is using is to seek dismissal of removal proceedings, particularly for people who are unrepresented in immigration court, and then to use that as an opportunity to then detain that person or arrest them and put them into expedited removal proceedings now that they're out of the regular removal proceeding process in immigration court. We have also seen folks being arrested at ICE check-ins, and to some extent, this has happened at USCIS as well, or when someone is seeking an affirmative immigration benefit, and there isn't always a rhyme or reason to it, but there's, again, ways for folks to protect themselves, including having someone accompany them, thinking about when they attend or when they go to those appointments, and yeah, sharing this mostly for your awareness because it is less likely to impact folks who are in the refugee or parolee categories, but it could impact some folks. And again, we will be focusing on ways to protect yourself at the end. Thank you. So some of the other executive actions to keep in mind here. The travel ban, this came during the summer at a time when I think there were so many other things happening, including a lot of this immigration enforcement activity, that we found even folks in our communities who are impacted by it might not have known that it actually went into effect, or how it has impacted them. And we have some explainers that we can share with you, but essentially there's a full or partial entry ban for nationals of 19 countries. There's full ban on 12 countries, and a partial ban on the remainder. And there are some exceptions. There's also, in theory, a national interest exemption, which would be a way for someone who would otherwise be subject to the travel ban to be exempted because it is in the US national interest to allow them to travel here, or to pursue that immigration pathway that has been impacted by the ban. But in practice, we have not really seen that happen. We have heard of some exemptions, but it seems that in many of those cases, that has happened for people who would have been in one of the categorical exceptions, rather than an actual national interest exemption. For Afghans, they are subject to that full entry ban, which primarily impacts many immigrant and non-immigrant immigration pathways, which or pathways to the US, right? Which means that it impacts people who would have received a temporary permission to come here, such as a student visa or a work-based visa. And it's also impacting people who may have had an immigrant pathway, such as certain family-based pathways. There are some exceptions, particularly for Afghans. The special immigrant visa falls under the exceptions, and there are exceptions for certain immediate family-based pathways, particularly for family members of US citizens. But what we're seeing in practice has been that some of the pathways that are not explicitly impacted by the travel ban, such as refugee family reunification or asylee family reunification, even those pathways have been being impacted in some ways. So there's a lot of delays here, and a lot of situations might need to be addressed on a case-by-case basis, but the general things to keep in mind are that Afghans are currently subject to the travel ban, and special immigrant visas are outside of that, but refugee pathways are still impacted, and family reunification for green card holders is still a little bit more complicated. For folks who may have filed humanitarian parole applications for their loved ones outside of the US, humanitarian parole pathway is actually not impacted by the travel ban, but it's still something that is kind of difficult to access, as it always has been, and is granted on a case-by-case basis. But it's possible for someone to still pursue that pathway. I'll just mention also that family reunification for Afghans in particular, the CARE team had been congressionally authorized to continue existing, which was overseeing family reunification for evacuees and certain SIV and refugee cases as well. But the reality is that that office has been understaffed and that many of the pathways that people were accessing travel based on were refugee pathways, and those are subject to the refugee ban. Okay, we can go to the next slide. So the refugee ban, again, this is impacting people across the board. Refugee cases have essentially been frozen for most refugees and people of most nationalities since January. There is ongoing litigation that is focused on people who were effectively ready to travel. They had passed through all stages of the refugee process and were slated to arrive in the US through the US refugee admission program until they were arbitrarily impacted by this ban. And the Pasito litigation has had some positive impacts since January and has resulted in some people who were ready to travel being able to reach the US finally. But it is pretty limited on the specific people who are included in that lawsuit. And it is not at this time a class action that would impact everyone who was ready to travel. Their current status of that is that it's kind of waiting for the developments from the administration, which the administration is set to release their annual presidential determination for the new fiscal year, which will determine the number of refugees that is like the goal for admission in 2026. And we have not seen that yet, but there have been some unconfirmed reports that were referenced in other news reports of a very low, historically the lowest presidential determination that has ever been set, which is for 7,500. We don't know if that is actually the case or not. We're going to have to wait and see in the next couple weeks, but that was referenced in a news story. The current expectation, or what we've been seeing in the past year, is that the only refugees that have been admitted have been very small numbers, as what I mentioned, of people who were already set to travel. There has been some resettlement for Afghan special immigrant visas, but the only new refugee admissions have been white South Africans, South Afrikaners, and it could be expected that that's what the new presidential determination would look like as well. But again, we don't know what that will actually look like. We can, I'll just add here briefly that there have been many other executive orders that are not necessarily immigration orders, but many that also are, that kind of indicate that this administration is using, it is continuing that sort of pathway of focusing on particular groups of refugees who look a certain way, who are from specific countries, and really scrutinizing political beliefs and all these things. And it is pretty blatantly discriminatory. So that's where these kind of expectations are coming from also. But we can go to the next slide. Okay, humanitarian parole and TPS. So when we talk about humanitarian parole, I try to think of two different categories where there's folks who have come to the US through a parole program, and OAW, or Afghan evacuees, technically was not a parole program that people sought admission to, but it kind of is a program because it is this category of parole that people received. So OAW or OAR, and then there's Uniting for Ukraine and CHNV. There have been some ongoing lawsuits from Justice Action Center and Human Rights First, related to these parole programs. In particular, the termination of parole for some of these folks and the targeted enforcement, including trying to place some of these folks into expedited removal. And that has had some positive developments as well. The current situation is effectively the status quo, where people who still had parole, people who had parole should still have that status. We have seen that for Afghan parolees who were in a position where they need reparole, or they need that parole status to be extended because their other applications are still pending. There have been some approvals of reparole in those cases, with the caveat that they might have to pay the application fees, because of HR1, which we'll speak about in a moment. One kind of impact of this, though, has been that for people who have lost parole or whose parole status is ending, they should really just be keeping an eye on that to make sure that they don't face interruptions in their work authorization. But we have been seeing that folks have been able to extend that status, or they have something else, for the most part. The difference would be for people who arrived in the US through an approved humanitarian parole application, which was that other second type of humanitarian parole questions that we have to do with people who had applied for humanitarian parole for their loved ones who may still be outside of the US, or who arrived through that approved application, which is really a different set of considerations than the people who are here through a parole program. Just will reiterate, though, that people outside of the US, humanitarian parole could still be granted on a case-by-case basis. It hasn't gone away necessarily, but it's, as always, a very difficult pathway. It's granted on a case-by-case basis. You have to pursue consular processing and reach a country where there is a consulate for Afghans. That means they have to get to a third country, and then would need to get a final approval. We haven't had folks pursue that in the last few months, but in theory, it could still happen. It's just not a guaranteed pathway. Termination of temporary protected status. Temporary protected status has been terminated for a number of countries. Just in general, TPS can be, or the statute allows for TPS to be extended for a short period of time after the status would have expired. So it's just something to note that the administration is choosing to actually terminate TPS instead of just letting it expire, which would have included that extension, which is why we're seeing lawsuits that are challenging this termination as unlawful. And they have been successful to a certain extent, with then getting an extra 90 days or so typically for TPS. But in general, folks who had TPS, that is expiring if it has not already expired for many groups of people, including Afghans, Syrians, Cameroonians, others. And there is some ongoing litigation, but there haven't been any recent developments beyond that. For Afghans, it was extended a little bit longer, but that it has now expired regardless. For folks who may have had TPS, again, if they had work authorization based on that, it's really important that they get work authorization based on something else. But there could be people who are not eligible for anything else because their asylum application has not been pending for long enough and they don't have anything else that would allow them to apply for work authorization. So unfortunately, that has left some people kind of vulnerable and potentially unable to work for some period of time. But it's really important that they speak with an attorney so they can assess their options. And that is where there's a lot of opportunity for community education and support on that. Reparole, again, folks may be eligible to apply if they need that, but they have to pay the application fees. So we'll go on to or before I get to that, I'll just mention that the folks who are in these categories of humanitarian parole, temporary protected status, and of course, it doesn't lead directly to a permanent status. And for most of them, they have to pursue asylum. Asylum is still something that folks can pursue, but it's definitely what we're seeing is that across the board, USCIS processes are facing a lot of delays right now. And much of the funding that is being authorized, including new immigration applications, are not necessarily going back to, or new immigration application fees are not necessarily going towards making USCIS more efficient so that it can address some of these backlogs. So it's kind of normal what we're seeing now that work authorization, EAD applications, the processing timeline continues to increase. It's not something to necessarily be alarmed about, but it is, of course, unfortunate that folks are facing these delays. We are still seeing green card approvals, asylum approvals, but it's just taking longer, and there may be many folks who are just waiting for their interviews and things like that. But we can go to the next slide. So the current situation with Congress, I'll just briefly share the government shutdown is currently in effect. This has happened because Congress could not come to an agreement around the spending and setting a budget. And a lot of the arguments have been surrounding immigration, which has included villainization of immigrants and sort of accusations of Democrats trying to use or sneak in certain measures that are not actually happening. So there's just a lot of myths that are going around about what policies they are trying to include around immigration, and the reality is quite different. So we don't know how long this will last, but it is definitely impacting the bigger picture of immigration policy right now. But all of that being said, a lot of the agencies are still functioning at this time, or the relevant agencies for immigration purposes. But the next slide. I think this kind of relates, but HR1, or the One Big Beautiful Bill, as it was called, which was this massive spending bill that was passed over the summer. We wanted to touch on some of the key relevant points that may relate to the folks that you work with. And some of the big changes here, well, probably the biggest component has been that it set a massive amount of funds to be used for immigration enforcement purposes, with many of those measures being enacted with certain requirements or mandates for how it's to be spent for immigration purposes. And there's incremental changes throughout the next months and years. So this will have a long-term impact as well as already having some immediate impacts. And it is impacting these policies at a federal level, but their state implementation, particularly as it relates to benefits eligibility. And so we are seeing some immediate impacts of states kind of reading in eligibility requirements that are not actually part of the legislation. So it is something to keep an eye on. And there are opportunities to potentially do education with lawmakers, and to, in addition, of course, to educating community members about the impacts, making sure that we are continuing to engage on this so that the folks that we work with who are not supposed to be impacted are not being impacted, and so folks understand what the impacts are. So access to benefits is a huge piece of this. This includes health care benefits, SNAP, food stamps, many other categories. The best way to find the eligibility information is by accessing that agency's website, I think. But the key points include that it's green card holders who are eligible for these benefits, which means that non-citizens, non-green card holders are no longer eligible for many of the benefits that they used to be eligible for. There are some exceptions there. So refugees are an exception. Refugees are supposed to still be eligible for these benefits, including SNAP, for example. But what I'll just flag is that we're seeing in Vermont right now that they are reading in that Afghan SIVs are not eligible, which we believe is a misunderstanding of the law. So there's a need to educate the state there and make sure that they're not creating additional restrictions that should not be there. I think I failed to mention, though, that green card holders are eligible after 5 years. So it's unfortunately really restricting eligibility for many people. For some of the other impacts that are going to be relevant to the communities that we work with, one of the most immediate ones has been new as well as increased fees as it relates to immigration applications. So there's new fees, which are kind of different from the typical immigration fees, some of them, at least. So for folks who are in immigration court, there are a number of new fees that didn't exist before, which includes an annual fee for a pending asylum application, new fees for appeals, increased fees separately for appeals and for many different applications, and the same with USCIS. So there are increased fees for most applications, which includes increased fees, as we mentioned, for humanitarian parole applications, but then there's also this new fee in many instances. So it's most helpful to look at a fee chart, which we'll put in the chat. But this, just for your information, some of those fees are not going to USCIS, as I mentioned. They're going to the Treasury, and it can be kind of confusing what you have to pay for each application, because this has created those new fees on top of the standard fee that is on the actual immigration application. The pending asylum application fee is something that will just flag that it just rolled out in the last few weeks, that at least that we're seeing it in practice with the folks that we are working with. And it has forced people to not only pay for their asylum application, but also to pay for every year that the application remains pending, which of course is outside of their control. So this is something that many people will need to be preparing for, and that, we really think it's important to inform community members so that they can find ways to prepare for these fees that they will have to pay. And also for the folks that might be interested in supporting community members, I think this is a really impactful way that they can be supportive, is helping folks address these fees. I did want to mention one other thing about the fees before we continued. One other main big change has been that the initial work authorization application for folks who have a pending asylum application and are eligible for an EAD based on that, there is now a fee for that, which is a big change, again, impacting asylum seekers, which may include many of the people that you work with. So that is another thing that they would have to prepare to pay for. We can go to the next slide. Okay, so I think I mentioned many of these, but these are just some of the important dates that some of these changes will go into effect. So as you can see, some are next year, some in 2027. And so we're really going to be continuing to see the impact of HR 1 in the years to come. And yeah, this is another thing to keep in mind, that many of the new fees are not waivable. So while there may be a fee waiver that you can seek for certain existing application fees and for the fees that go to USCIS, the new fees are not something that someone can prove that I can't pay this and then be exempt from it, unfortunately. But the next slide.
If I could just add one more thing, Laila, about the fee waivers. It is a bit confusing. There are what we have been referring to as agency fees, and then there are the HR1 fees. So if, for example, an application to USCIS is $500, but the additional fee is another $500. The agency fee may still be eligible for a fee waiver. However, that additional one isn't. So I just wanted to make that a little bit more clear, that in case it's confusing later, how to incorporate a fee waiver into them.
Thank you. Right, so yeah, I'll actually pass it to you now, Sara, to take us through the next section. Yeah, hopefully that was some helpful context for why all this information about non-citizen rights is relevant now, and kind of what is in place to allow for increased enforcement and the changes to immigration processing that folks are facing.
Great, thank you, Laila. And just a reminder, if you have any questions, please feel free to use the Q&A and we'll go ahead and answer those at the end. And we are also including a lot of these resources in the chat, so you can load those up and save them for your reference. And I believe you will get the slides after, along with the recording. So this is just...
Sorry, really quickly before we move on, there is one question about the previous slide. It says, from whom will the access be revoked for the 3 examples given?
I will put that in the box for folks to see, just to make sure I don't miss anything. But the primary change has been that anyone who is not yet a green card holder is not eligible for majority of these benefits, with the exception being that refugees should be eligible, and some states have now been reading in that SIV holders who should be treated as refugees, we believe, are not eligible. So refugees should be eligible for many of the benefits still. Green card holders are eligible, but folks who are asylum seekers, I would say, is the biggest category of people that we would work with who are no longer eligible for many benefits.
Thank you.
Thank you. Yeah, that's a great question. So this is just a quick roadmap for the remainder of the presentation. Some rights to be aware of in relation to healthcare, housing, when interacting with law enforcement, including ICE, and then just some tips about what kinds of documents are helpful, as well as similarly your constitutional rights in public and private spaces. So as Laila mentioned, that there's a lot of access to benefits that are being reduced significantly for non-citizens, and that is a big departure from, especially in California, where even undocumented immigrants were afforded access to Medi-Cal and medical benefits. So that is a bigger change that we can kind of get into more, but I think a big takeaway and important reminder is that nobody, regardless of their immigration status, can be denied access to emergency care. So they shouldn't even be asking immigration status in a hospital, for example. And if for some reason they do, that information is not reportable. That's actually covered by HIPAA. So it's really important for people to know that, hopefully, and it's a more expensive option, but that they shouldn't fear getting access to emergency care when they need it. They cannot be refused care in California. Similarly, just because you're not eligible for benefits, it does not mean that you're not you should not receive care. So that's an important distinction that people should be aware of. It obviously creates complications as far as affordability. However, for the public safety, they should know they're still afforded access well, access is the wrong word, but you are entitled to care, just not the benefits that would help pay for it. So, yeah, again, they generally, these facilities can refuse enforcement, but only in areas that are considered private. I believe we talked about it at the beginning of the presentation, and I'll go over it in a little bit more detail with regard to our constitutional rights. But there's a distinction between where ICE can access if it's considered, if it's your home, but if it's a public space, there are still private spaces within that public area that employers, healthcare providers, et cetera, can refuse to consent access to. So if anyone is having, is being denied access to healthcare or receiving any questioning, or they think that their immigration status has been reported or leaked in some way, definitely keep documents and evidence about that, because even a non-citizen still has rights with regard to that particular area of healthcare. As always, we think, talking to an attorney is always important to see if you have experienced discrimination, but nonetheless, just knowing where you can and cannot access that healthcare is super important. Let me check my notes actually. Yeah, so even if you are asked for your immigration status, you do not have to provide that, because a healthcare provider cannot refuse to treat you just because you've declined to provide your immigration status. Okay. Similarly, federal law does protect individuals from facing discrimination and accessing housing, including on the basis of their immigration status. But similarly to healthcare, non-citizens can be excluded from receiving housing benefits, for instance, Section 8, or other credits that may increase affordability for a non-citizen. You also cannot be retaliated against or intimidated on the basis of your immigration status, and landlords still can receive face legal consequences for even threatening to report somebody on the basis of their immigration status. Importantly, because of our Fourth Amendment rights, there's a lot of protection in the home, even as a renter. So a property owner definitely can refuse consent and must expressly give ICE permission to enter, but renters can refuse entry of ICE into the property, which we'll go over in a moment as well. Yeah. Again, keeping records of any threats, especially on behalf of your landlord, if they are intimidating a client or an applicant, asking questions that are not relevant to whether they are paying the rent, kind of documenting any conversations, even if they're not in writing. A good practice is always to write a follow-up email or message saying, here's what we talked about, let me know if this is not correct. Can be a good way to document something that otherwise is not in a letter or email, to make sure that they protect themselves, especially if it's something that violates this protection against discrimination on the basis of immigration status. So I won't read exactly off of the slide, but the next couple slides are all related to the rights within the home and out of the home. So in either case, I'll start with the home. So any person in the United States, regardless of their immigration status or any other basis, has a right against unlawful search and seizure in the home. This means that law enforcement, again, be it the FBI, local police, or ICE, and this includes ICE, cannot enter somebody's home to arrest them without either consent or a warrant signed by a judge. So the ways that people can protect themselves, especially when they're in the home, is to never open the door for ICE. So that implies consent, and once the door is open, ICE can come into the home and arrest a person. A lot of people don't know that they can deny ICE or any law enforcement from entering the home. If you look out the peephole or a window, notice that it's ICE, a Ring camera, you can tell them you do not have to open the door. You can ask them if they have a warrant. They might try to trick you. They might say, yeah, we do have a warrant, and show you a piece of paper. I'm sorry, I'm used to speaking to the clients, so I say you, but the applicant, the client, they may show them a piece of paper that says, yes, I have a warrant. Please make sure that the applicant or the client knows that they should ask for the police or law enforcement to pass it through the door, a window, something, so that they can review it. This is really important because it is not unheard of for ICE to show something called an administrative warrant, which is not the same thing because it does not need to be signed by a judge. We need to make sure that the warrant has a name and a signature of a judge. Sometimes they'll have unsigned judicial warrants, sometimes they'll have administrative warrants, and they want to make sure that that is what they have. So without that, they don't have to open the door, and ICE cannot enter. Now, if they do enter the home, this is a different issue, or excuse me, if they do have a signed judicial warrant that's valid for the person living there, they can enter. And this is when the Fifth Amendment right against self-incrimination comes into play. The person who's being detained or arrested does not have to tell them, does not have to speak to them. They have a right to remain silent. This is really important. You should, the applicant client should not try to talk their way out of it. It usually doesn't help. Let someone else in the home know to contact an attorney, and we can share some our rapid response resources about rapid response hotlines and organizations that can kind of help deal with the initial next steps following a detention. So another important thing to consider when if ICE has entered the home with a valid judicial warrant that's been signed, is to never provide any false documents, never lie to ICE. Again, that's why remaining silent is so important. And hopefully it goes without saying that running and evading ICE is also not is not a good idea. It is an unfortunate reality if you are detained, especially in the climate. I understand the impulse to want to run and evade ICE, but ultimately it is more harmful than likely that they would get away. So while I sympathize with that impulse, trying to remind people that there are steps that the family and any legal advocates can take, hopefully will help them ease that impulse to try to run away from them. Okay. Going to the next slide. Okay, so this is similar to what I was just explaining about law enforcement in the home. These are tips specifically about the home, but they are similar but different if someone is being pursued at work. So ICE has the right to access any public areas, as we mentioned before, in a workspace. However, they do not have the right without consent or a warrant to enter a space that is not accessible to the public. So this can be like a locker room, a lunchroom, any space really can be not accessible to the public if an employer puts up a sign that says authorized personnel only. So, if you think about entering like an ice cream shop, the lobby where people are making requests, ICE can access, but they cannot go behind the counter and access things there. So it's important for clients and applicants to talk to their employer about not providing consent to ICE, putting up signs that distinguish where is authorized for someone to enter and what is not, to protect their employees from having this kind of interaction at work. However, again, if they do say that they have a warrant, the same thing, and I repeat this every time because it's super crucial, ask to see it, double check that it's not just an administrative warrant, make sure that it's signed by a judge and that it names the person that it's actually there to allegedly apprehend. So that's one thing that's different at work, that there is this kind of distinction. If you think of ICE coming to the door, that's public. ICE entering the someone's job may technically be accessible, but making that distinction about where they can go after that. And there are actually some ILRC red cards that are, you can order them online or print them in a variety of languages. We can put that in the chat. And it's really important we hand these out at every event that we go to, but would recommend, I think the website that we have has a list of all the languages that they have it in. It's in English on one side and then the selected language on the other side. Super important to keep that on them. It's very normal to panic in those moments and not know what to do. I always joke I got pulled over a couple months ago, and with all of my training and all of these things that I tell people, I felt this like nervousness to talk and explain what why I didn't do what they thought I did. But that's why I think it's important to kind of go over these so often, because there is this like inherent protection that comes out of us in those moments, especially when we're fearful or we could forget everything that we've heard a million times. Having that card on them is really important, not only so they can study it, but because they can also pass that card to the officer through the door without having to say anything more. So I would highly recommend that any clients that you're working with have those on hand. And if they're in the Bay Area, we have events, outreach and tabling events. We can definitely share those with you in case they would like to come and get some of those printed ones from one of us. And then I'm just going to briefly go over, I'm not sure how relevant this is to the communities that you're working with, but there are a lot of travel implications now for people who, for instance, have student visas or even traveling on a green card. People might have a refugee travel document for whatever, or even for citizens to be aware of, that upon re-entry to the United States, we have heard reports of questions related to activism, work, immigration status, political beliefs, criminal history. If someone does have a criminal history, even if they're a green card holder, make sure that they're talking to an immigration attorney before they leave, because anyone who's a non-citizen has significantly less rights at the border. And so they are pushing that to the extent that they can. And something like a criminal history can be used against somebody upon reentry. So it's really important to make sure that that's not something that's going to prevent them from reentering the United States. There are reports that people are having their electronics searched, forensic copies made, and their devices can even be seized. So CBP, and I think the next slide actually has like what they can and cannot do. Yeah, so CBP can inspect belongings, ask about the trip, and even confiscate electronics. However, they do have to provide a receipt for that. So we have, there are some I think there are differing opinions about what's the best way to travel with electronics. Some suggest, like a complete burner phone. Some say to, back it up and factory reset your computer upon reset. This is, again, more for perhaps even for some of the attendees today, depending on the kind of work that you do. Just making sure that you understand that those can be searched and even made a copy of. Sometimes they will hold somebody to extended questioning, and then use give me your computer, give me your phone as a way to get out of that questioning. So something to be mindful of as far as what you feel comfortable, the level of risk when traveling with electronics, assuming that they could be searched. Of course, millions of people are traveling every day. We hear about a handful of them, but with all of these tips, you don't want to be caught without a plan. If, God forbid, you are one of the people who is singled out for that. So a CBP can't ask you, they can't target you based on your race or ethnicity or ask you relevant personal questions. Specifically for green card holders, well, anyone should not be signing or filling out any paperwork if they are in secondary inspection or prolonged questioning. But specifically for green card holders, there's a form I-407 that basically consents to abandoning your lawful status. This is something we've seen used as a form of, again, getting out of prolonged questioning or detention. So you want to make sure that that is not being signed because that is effectively giving up your green card status. Similarly, if you do have prolonged questioning, confiscation or seizure of your electronics or any devices, you want to make sure that you document that, get the officer name, their badge number, get a receipt for anything that's been taken away. And this can help in a civil inquiry or something later if you think that your rights have been violated or the applicant's rights have been violated. Laila, did you want to add anything to that?
Yeah, I just wanted to reiterate that anyone can be asked questions and anyone can refuse to answer those questions or refuse to participate in a search by handing over their devices or something like that. But the reason we really encourage folks to consult with an attorney before any planned travel is because for a citizen, you cannot be refused re-entry if based on your refusal to answer questions or to allow for CBP to search your devices. Before a green card holder or anyone else, you could potentially be refused re-entry. So that's just something to keep in mind. It's unlikely, but it is possible.
Great, thank you. Okay, oops.
Sorry, I'll just add very briefly to add to that is because your rights are different when it comes to CBP and a port of entry versus within the US. So within the US, the same still applies that you, regardless of your immigration status, you can refuse the search or refuse the questioning.
Yeah, that's a great point. Thank you, Laila. So yeah, hopefully all of this information has made you feel empowered and informed about what can and cannot happen, what steps you should and should take to protect your clients, protect yourselves. Doing a training like this is exactly something that that we recommend that people do, so that that information can trickle down to communities that we may not otherwise reach. Again, just kind of reiterating what we already went through, making sure that somebody is reviewing any warrant. That can be someone who's English speaking in the home or a friend, but just knowing what to look for. And then, of course, talking to an immigration attorney is the best option. We also have, I think we have a link for an emergency preparedness, a family preparedness explainer about some best steps to prepare for the event that someone in the home is detained. This has, next steps or context for childcare, any kind of documents that are important. You're really preparing for the worst case scenario. If you have an attorney, their information can be in there. We have a link that we can share that gives a really detailed explainer about how what kind of information it could be like a binder, and what kind of information should go there, who should have access to it, what are some immediate steps that people can take. it's preparing for a situation where the breadwinner is gone, or the person who provides childcare to their children. Who do they go to? Who can pick them up from school? Making sure that we're communicating with the school, things like that, to just have it all in one place, so that the family members who are impacted, who have not been detained, know exactly where to go and what next steps to take. Another thing that we always want to warn against is the spreading of misinformation. Even the most well-intentioned advocate, there are a lot of community members that try to help one another out. It can be really expensive to have an immigration attorney. So it's natural that a lot of information goes through word of mouth, but this can provide a lot of complications for people. They can have false hope. They can be ill-prepared. They can, on the other end, panic when there's no need to. So it's really important for people to have a clear understanding of what's going on. There have been a lot of changes in the last, 10 months now, and it's a lot to keep up with. So something that they might have heard of 4 months ago may have changed. It may be better, it may be worse. So you just want to make sure that they are in the habit of confirming any information that they get, talking with trusted caseworkers or attorneys or organizations, getting their information confirmed from somewhere else besides the community member is a really good practice to just make sure on both ends of the spectrum they're not worrying unnecessarily, but are also not unprepared based on misinformation. And I'll just finish this up. This is our contact information. We do have a request for assistance form on our website that you or an applicant can directly use to get in touch with us. We also have our WhatsApp, email, and just our regular phone number. And yeah, I'll leave it there. Hopefully that's enough time for questions.
Yeah, thank you both so much for all of the information and resources shared. I invite folks, if you want to come off of mute and ask your questions live, you can raise your hand and then I can unmute you. Otherwise, you can put your questions in the Q&A box. There was one question in the chat from Wagma. So their question is, how would an Afghan family who has no education understand if the warrant is from the court or if it's an ordinary document?
Yeah, oh, go ahead. Yeah, that's a great question. So this is kind of why it's important that if people may not be able to read English or may just even be intimidated by such a task. And again, that's why I brought up that impulse to do something other than what is this really methodical recommendation of how to interact with ICE. As long as they're looking for the judge's name and the judge's signature, it should say at the top, judicial warrant. Maybe we can find an example and put that in the chat, or we can send that to you guys after, Jasmine. But there's things that they can look out for to confirm, so they don't have to read all of the contents and they don't have to overwhelm themselves with wondering if it's correct or not. The thing that we always tell people to look out for is that signature by a judge. And we do understand that this is intimidating. It can be really overwhelming in the moment to think that you're making like a legal decision. But those are some of the bare minimums that they should take a look for to make sure that ICE is actually presenting them with the proper documentation to attempt to detain somebody.
Yeah,
Laila,
and
did you want to add something?
yeah, I'll just point out that we did put the examples of a judicial warrant in the chat, and also we put the California Rapid Response hotlines in the chat. So those are a couple resources which would hopefully be helpful. I think we really just encourage folks to preemptively familiarize themselves with these things in case, because it's just better to be safe than sorry. So I know there may still be barriers for many folks in the community, but whatever we can do to familiarize them, to encourage them, look out for that judge's signature, or this is what it looks like if it actually comes from a court. A majority of the time, what ICE has doesn't actually comply. So if they're looking out for those things, that is a protection. If they have someone trusted that might be able to help them. So if they might have issues with, being able to communicate with the hotline, is there someone else that they could call to, who can call for them, or who can help them make that call, or who can help them review something, in case that's necessary. And if they really are, um, have like the red card, know your rights in mind, then that gives them some more time and at least understanding of what questions to ask so they can get the information that they need, and then be able to call someone else. And then we also had that family preparedness resource, which is another thing that people can do, which can walk you through some of those steps of what to do in case of facing enforcement activity, who to call, and anything like that. So there are a number of resources that folks can access in the case of an emergency, like those rapid response hotlines. And it's better to call early, but also to just understand or have the expectation that if someone unfortunately has been detained, then it's likely going to take some time for them to get help. But prior to that, especially, or if there's ICE activity happening, or if people have questions, they can definitely call one of those numbers. And then, yeah, there is a sample order within that ACLU link, so you can see what it looks like and what to look out for to make sure it has those components.
Thank you both. I'm seeing questions in the chat and the Q&A box. Let me know if it's helpful for me to read those out loud.
I can address this very last one right now. The person waiting for reparole, is it considered a non-legal status? So parole is essentially a permission to be legally present in the US. It's not an actual status in the sense that it doesn't give benefits directly in most cases. For Ukrainian parolees and Afghan parolees, the Congress authorized resettlement benefits for those categories of people. So that is a little bit different. And so there could be some benefits based on those statuses, but it does potentially protect someone from enforcement because it shows that they have the permission to be here. If the parole has already expired, then we would look at what else do they have. So if they have an approved application, for example, in SIV, if you're somewhere in the SIV process, then it's possible that you have some sort of status based on that, and your parole has expired, then they might still be in some sort of legal status. If they have a pending asylum application, then that could be a form of protection. If they have an approved asylum application but aren't yet eligible to receive their green card, then there could be some form of protection there. So it really is like a case-by-case question of whether that person has legal status or not. But expired parole is, and nothing else, does make someone vulnerable. And that means that they're not in a current legal status if they have nothing else, but it's possible that they have something else. So yeah, that person would definitely want to speak with an attorney, and we would really encourage you to reach out. If they are Afghan, then you can put them in touch with us if they don't have access to legal services, so we can have a consultation with them. But hopefully that answers that question.
Yeah, thank you, Laila. And I was also wondering if maybe you could speak a little bit to some of the services that you offer and how folks can refer clients to you.
Yeah, so we encourage folks to reach out through our website, and on our website there is a form to fill out, and you could also email us at hello@projectanar.org if you want to refer a client, but it would be most helpful to have them either that way or through the website form. And we are a very small organization, which is why we're not in a position necessarily to do, rapid response eh, services all the time. So just for folks understanding, a lot of the majority of our services are through large scale workshops where we are helping many people at one time, and our attorneys are helping to prepare the applications, review the applications, and file the applications for a particular type of immigration application, primarily asylum, green card or adjustment of status, work authorization, and things like that related to protection or permanent status in the US. And we often are able to also do consultations for asylum seekers and refugees primarily. And we also assist with family reunification. So we are always happy to review requests for assistance and to assist people, especially through those workshops. But we generally wouldn't be in a position to help someone who has their case in immigration court, except on a case-by-case basis or through our volunteer network, because we do have volunteers to assist. However, we might be able to help with a part of your case. For example, if someone's in immigration court and they haven't connected with an attorney and they have their court coming up, we can potentially help them prepare for that or understand their process. If they are facing the 1-year deadline for filing their asylum application, then we might be able to help them with filing their asylum application and things like that. So that's generally what we are in a position to help with right now. But again, we receive requests from anyone, and we always do our best to help in some way, whether that's sharing information, doing a consultation, or eventually assisting them directly.
Thank you so much. All right, I see 2 more questions in the Q&A box. So if the judicial warrant has a date but does not specify the time the search can be executed, is it considered valid? For example, what if neither of the check boxes are on the sample judicial warrant are marked?
So I think that's a good eye. And if you have something like that where you can point out this is not fully executed, then yeah, we would say try to use that to show that it's not valid. It is supposed to be fully executed and completely filled out. And it's not uncommon for things like that to happen. The same with like a notice to appear. We're always arguing if there's something missing that it's not valid. And in some instances that works, and sometimes the court might not agree that it's not valid, but we would always try to point that out and use that to demonstrate that it's not valid and that they're not in compliance with their requirements to be able to conduct enforcement activity.
Thank you. There's also another question in the chat. Are the Ukrainians who came after August 16th, 2023 eligible for TPS? Not sure if you'd know the answer to that, but.
Let me see. I will just double check the dates for Ukrainian.
Yeah, I'm sorry, I don't know off the top of my head.
I will put a resource here about TPS in general, which should be helpful. But I don't believe that TPS has been extended beyond the initial designation dates, or there was one extension a couple of years ago, but it hasn't been extended since then. Here we go.
Yeah. And it looks like that you have to have entered before August 16th. So that seems to be the cutoff, and I don't see a extension of that date.
Right. Yeah, I don't see an extension of the date from August 2023.
We have just a few minutes left. If you have additional questions, please feel free to ask them now. I'm also going to put a survey link in the chat so you can give us feedback on the presentation today. But I'll just leave some time if there are any last questions. Yes, so I have seen a lot of questions about sharing the slides and recording. So I will be sending an email to everyone who registered probably later this week, tomorrow, or in the next few days, with the slides, the recordings, all of the resources that were shared. So you'll be getting all of that information. And I see a question, where can we see the information connected with the latest news for immigrants?
I'll also just point out the USCIS website. If you search like USCIS TPS, you can go to their webpage that has each country on the side and the eligibility. I would encourage reviewing that for the most up-to-date information also, in case anything changes. And yeah, we would encourage folks to, you can keep up with us on, join our newsletter and social media, and we share a lot of updates that are community facing especially, and as you can see, NILC and ILC, they have a lot of resources. ILRC has a lot of resources, and those are good websites to keep up with as well, or listservs, or sorry, newsletters to join.
Thank you. And Ludmila, I see you had your hand raised. Would you like to come off with mute and ask a question?
Yes. Do you hear me?
Yes, we do.
Thank you, Laila, for your answers. And I have the last question as for TPS for Ukrainians. Am I correctly understood that the person who came after August 16, 2023, they cannot submit for first TPS for first time?
So the requirement, and this would apply to any country that currently has TPS, it can be kind of confusing because there's multiple dates in the designation. But the August 16th requirement is that they had to have been in the US since at least August 16th and continuously living in the US since then. So that's correct. If they entered the US after that, then they wouldn't be eligible.
I see. Thank you. So, are there upcoming updating situation as for this situation for Ukrainians who came after this date?
There might be advocacy underway to extend or redesignate the TPS designation for Ukraine. At this time, I'm not aware. I don't know, Sara, if you are aware of any expected extension of TPS for Ukraine. But I would say that there's a lot of ongoing advocacy. Actually, if you follow the National TPS Alliance, they're currently doing a week of action for TPS for everyone. because many groups of people have recently lost TPS, and those who have it, of course, want the protection to be continued. So this week there are a lot of updates and actions going on.
Thank you, Laila.
I see. Thank you so much.
All right. And one last question in the chat also, will you be providing trainings on how to help families fill out family preparedness plans?
I don't know, is that directed to us? We don't have any plans for a training. We have been considering preparing a document in Dari and Pashto for our Afghan clients. If that's something that others would find helpful, maybe we can think about doing a KYR or webinar or even just a web recording for some best practices. I think that's a great idea.
Right. Well, thank you everyone for joining us today and for taking the time to learn together at a moment where there's a lot of fear in our communities. And also, again, thank you to Laila and Sara from Project ANAR for sharing their expertise and experience with us, and also just your dedication to supporting the Afghan community. We hope today's session has given you some helpful tools and resources to strengthen your own Know Your Rights efforts. And yes, please keep an eye out for a follow-up email from refugeeschoolimpact@phi.org with today's materials, resources, and ways to stay connected with us and with Project ANAR as well. And thank you all for your engagement and for the work that you're doing to support immigrant communities. And we look forward to seeing you soon. Thank you, everyone. Have a great day.